morning and welcome everybody to the second AI Policy Conference. My name is Sanja Fabrio. I'm co-founder and managing director of RegHorizon, that together with the Center for Law and Economics of ETH Zurich will be a host for this two-day event. Artificial intelligence, as we all know, is a very powerful tool that carries enormous potential to bring good to the world. But in order to benefit from these new technologies, as society, we need to address the key risks they generate, as well as the concerns we all have as citizens, parents, scientists, or business people. We started this dialogue last November during our first AI Policy Conference, and some of you may have attended it already. Today and tomorrow, we will build on the key takeaways from our last event, but also take into account the new developments in the governance of AI. This dialogue on effective governance of AI becomes ever more important with its rapid development and deployment. We now start seeing regulatory proposals at national, supranational level, as well as initiatives such as standards, principles, policies, as the efforts increase to align governance globally. We will address these governance initiatives, as well as how they will be impacting society and business, with today over 50 international experts, global policymakers, engaged civil society representatives, and top scholars during these 2 days of the conference. We will do so through 2 keynotes, 6 panels, 2 research spotlights, and 2 academic paper workshops. For all who haven't checked the detailed agenda, please go to event page www.reghorizon.com events. And you will find that both the speakers and the detailed agenda, as well as their bio. To build governance frameworks that are well conceived and that can and will be adhered to, we need to bring all relevant parties to the work together. This must include policymakers, business, both small and big, academics, ethicists, social change makers, and civil society. And most of these groups are represented today, both as the speakers and in the audience. When my co-founder, Ayisha Piotti, and I established RegHorizon in 2019, we realized that we have a great opportunity here in Switzerland, where we are based, to have so many of these relevant parties around the table. Why is that? Well, you know that Switzerland is a global hub for innovation. It has excellent academic institutions, including technology powerhouses such as ETH Zurich and EPF Lausanne. It is a key anchor to international organizations with its International Geneva. It is a host to numerous headquarters for multinational businesses, and it has an unmatched reputation as neutral and pragmatic country. Multilateral, multi-stakeholder approach to developing global AI governance is now needed more than ever. Like our speakers and panelists, you are a truly global and multi-stakeholder audience. And if I can ask Arvind to show the slide representing your geographical provenance and your affiliation, you will see this for yourself. You come from many, many countries. I guess half the globe is represented. And an interesting part is also your affiliation. So second slide, please, Arvind. You have a private sector and academia of about 1/3 each, but we also have the government, NGOs, and citizens, and it's such a great picture to essentially have in front. We are very, very sure that there will be a lot of questions and contributions. So, and we really look forward to this interactive session with you. So my colleague Ayisha Piotti, who I passed it now, will introduce the covered themes, the format, and the post-focus areas when the event is over. Ayisha?
Thank you, Sanja. Hello and welcome everyone. I'm Ayisha Piotti. I'm the co-founder and managing partner of RegHorizon, and it's my great pleasure as well to have you here with us today. So why are we here today? As you briefly heard from Sanja, the key challenge we face as a society is how to capture the benefits of artificial intelligence, but at the same time, minimize its risks. Or in other words, how do we ensure that AI is developed for the public good? Now, whilst this question is critical, it generates many different answers depending on who you ask. In a democratic society, lawmaking is an important way to find solutions to challenges such as the one we are facing today with AI. However, It is also critical that the process is inclusive and the citizens, elected representatives, and businesses are well informed and empowered to have their voice heard. So when we started this partnership with ETH Zurich Center for Law and Economics, we felt that more needed to be done to raise awareness of this topic and to facilitate a multi-stakeholder exchange. And our first AI policy conference laid the foundations for this dialogue. Now, as the debate shifts from the need to put in place ethical frameworks and principles around AI to the need for binding regulations in the area, raising awareness of all stakeholders and inclusive participation in the process becomes even more important. So the agenda for our conference reflects this objective. Overall, our conference will tackle the following questions. What is the latest in AI policy developments in terms of binding regulations, but also in terms of soft law? What are the views of the different stakeholders about this? And how can we prepare for what is coming? Panel 2 and panel 3 will look into this. Next, are all voices being heard and all points of view being shared during the lawmaking process? And how can we improve this? Panel 1 and panel 6 will explore this. And how can we build trust and enhance the adoption of AI through innovative approaches and through data policy? Panel 4 and panel 5 will dig deeper into this. And of course, what are the latest contributions from academia on this topic? The academic spotlights and paper review sessions run by ETH Zurich will be the place to get insights into this. Now, as Sanja mentioned, you can download the full agenda of the conference on our website, which will give you the complete overview of all the discussions, including the keynote speeches, which I must say are truly worth listening to as well. Now, on behalf of RegHorizon and ETH Zurich, I would like to take this opportunity to also thank our partners for all their help and their support. Our sincere thanks to the Swiss Federal Office of Communication, the Swiss Academy of Engineering Sciences, Switzerland Global Enterprise, Geneva Macrolabs, Youth IGF, Empowerment Foundation, the AUS, and the Diplo Foundation, all of whom have not only contributed towards this event, but have also committed to be actively involved going forward. Of course, a special thanks to Professor Elliot Ash and Eileen Nielsen from ETH Zurich, with whom we created this concept and with whom we will work closely going forward as well. Thanks also to Shalini, Katarina, Christina, and Natasha for moderating the panel discussions along with us. And of course, Arvin, who is with us all through for his help and guidance on all technical issues. Now, your views are important to us. So all through the conference, we'll be running polls and Q&As. So please do participate and make sure that your voice is heard. You will also have networking opportunity through the meet and greet sessions, through an application called WonderMe. And I recently tried it, and I can tell you, it really is quite amazing. All you need is your browser and your camera, and really you're good to go. I think we will be sharing the link for that, so you can sort of start going through the lunch breaks as well as coffee breaks. Try it out. Now, lastly, a key objective of the conference is also to build on the discussions. So we will run debrief sessions with all our panelists and partners in the coming weeks, and we will incorporate their input in a summary publication highlighting the key reflections from this conference and the next steps going forward. You as a participant will get access to this publication as well as the recordings of all the sessions. So thank you all for being with us today. We truly have a global conference, as Sanja mentioned. I wish you all a great 2 days of ideas exchange, and I hope that by the end of these 2 days, you will walk away with tangible insights, which will be helpful for you as a business leader, an academic, a public servant, and most importantly, also as a citizen. So that's all from me. I will now yield the floor to Professor Stefan Bechtold to welcome all of you, also on behalf of ETH Zurich Center for Law and Economics, and to kick off our session by sharing some of his reflections on the topic. Stefan, the floor is yours.
Great. Many thanks, Ayisha, for the kind introduction and also a warm welcome from me. And I'm going to share my slides. You should be able to see them. So what I'm going to do over the next 20 minutes or so is I'm going to share some thoughts about how to regulate this space, how to regulate AI, and the lessons we have learned from other areas of technology regulations over the last years. So if you think about how to regulate a phenomenon like the internet and all the applications that are building up on the internet, the traditional way to regulate this would be through international coordination. So this would be, kind of a bottom a regulation from the top, where institutions such as the United Nations, the International Telecommunications Union in Geneva, and other international bodies would set standards for the world on how to interact in cyberspace. Now, it turns out that this way to regulate is only one way, and there are also alternatives. So if you think about what has happened, not only in kind of internet regulation, but in regulation more generally, countries have increasingly used their own regulatory powers in order to set global standards, or at least to influence the regulatory landscape outside their own borders. So think about the US banking laws that have had a huge impact on Swiss banking laws, for example, a few years ago. Think about US trade sanctions, but also think about European antitrust law or the General Data Protection Regulation, which I'm going to talk a bit about in a few minutes. Think about the California Consumer Privacy Act, which is not only applicable to consumers and businesses located in California, but can also be applicable to firms located outside California if they serve consumers within California. So the alternative is a world in which there's regulatory competition, in where countries are competing to become leading global rule makers and set global standards. And the European Union has arguably played an important role in that space. And the question that I'm going to focus on is to what extent the European Union will be able or should be able to repeat this strategy in the space of artificial intelligence. So if you look at the recently proposed regulation by the EU, the proposed Artificial Intelligence Act, you see certain signs of that strategy. So in April 2021, the European Commission proposed a regulatory framework encompassing any AI system that touches the single market, irrespective of whether the provider or distributor of such AI system is based in the EU or not. Now, this is just a proposal. The European Parliament, member states will need to adopt the proposal, most likely in a revised form. And this goes through the normal legislative channels. But if this proposal in whatever form at some point will get adopted, then it will directly apply across member states because it's most likely going to be a regulation. Now, what are some key components of the Artificial Intelligence Act that are at least important for us today? So it's a risk-based approach. So the legal and technical obligations that are imposed on AI systems depend on the classification of the product and service as either having a low, medium, or high risk, and some specific AI uses are banned outright. So the risk-based approach is directly embedded into the draft regulation. The AI Act has an expansive definition of AI systems. It requires extensive documentation, training, and monitoring requirements. What's important for our purposes is that there is an extraterritorial application to a certain extent, because the AI Act would apply to any provider or distributor of AI whose services reach the EU market. And so this includes situations in which a foreign provider or user outside the EU uses an AI system in a way that the output of the AI system is used in the European Union, whatever used then actually means. There's a broad definition for AI, which includes machine learning, expert logic systems, but it can also include Bayesian or statistical approaches. And this has led to quite some discussions on the extent to which, ML systems should be treated differently than more traditional statistics technologies. Now, if you have followed the AI Act, this is probably what you've seen in some way or in some version before. So a corner principle of the AI Act is that it would classify different AI products and services into different risk levels. And so this is just an overview from McKinsey on what this could mean, so that there are some systems which are basically just banned or outlawed because they are unacceptable. Social scoring systems to a certain extent. Then there are high-risk AI systems, for example, credit checking systems that would be subject to more rigid regulation. And then there are limited and minimal risk AI systems, chatbots, games, and so on, that are subject to less regulation by the AI Act. What's important for our purposes is that the penalties are strict. The penalties are even stricter than under the GDPR in cases of engaging in practices that are prohibited by the AI Act. This can lead to fines up to either 30 million or 6% of the worldwide annual turnover of a company, whichever is higher. And that is, of course, a huge amount. Under GDPR, this is 4%. These high fines that can be imposed come from European competition law, antitrust law, where the 4% have been around for quite some time and enable the European Commission to impose large fines in case of antitrust violations. So what are some of the key points that are important for us here? There is the potential extraterritorial application if the output of the AI system is used in the European Union, and there are large fines. So for those of you who have been following, European policy making in that space, of course, this reminds us of the GDPR, of the general data protection regulation. So to some extent, the question is, is this just a GDPR 2.0? Will the European Union be able to enact a similar statute concerning artificial intelligence? Will it be, similar in success as the GDPR arguably has been? So the GDPR, for those of you who haven't followed this, is the general data protection regulation. It harmonizes national privacy rules across the European Union, came into force over 3 years ago, and has lots of rules on data protection, including technical and organizational rules. It also revolutionized privacy law in Europe because it drastically increased the sanctions regime. Fines are up to 4% of the global revenue. Before that, depending on countries, the maximum fines were kind of 6-digit euro numbers, which typically were much lower potentially than the 4% regime. And the sanction regime had much less territorial scope. There are rules about joint responsibility. So if your website that outsources certain parts of your web technology services on your website, if you outsource this to third-party companies, then you may still be liable for what these third-party companies are doing. This has already reached the European Court of Justice when it comes to Facebook and like buttons, for example. And what's also important for our purposes is that GDPR, similar to the AI Act, has a broad territorial scope. So it applies to companies offering goods or services to individuals located in the European Union, regardless of whether the companies are located in the European Union or not. And so if you think about this, in a more systematic way, there are basically four potential constellations in which the GDPR can apply. Is the website audience located in the EU? When it comes to websites, is the website itself, the company providing the website, located in the EU? And so if both of them, the audience, the consumer, and the website are located in the EU, then the EU, the GDPR applies. If the audience, if the consumer is located in the European Union, but not the firm operating the website, then the GDPR still applies. If the website is located in the European Union, but the audience, the typical audience of the website, is located outside the European Union, the GDPR still applies. And the only case where, from a legal perspective, the GDPR does not apply is the case where both the typical audience of the website and the firm operating the website are located outside the European Union. So, and the reason why I'm giving you this background is that first, with a group of colleagues, we ran a study that was interested in the de facto effects the GDPR has had on competition and market concentration. And then in a second stage, I'm going to talk a bit about what this means for regulating AI. So what are the effects of the GDPR on regulatory competition between countries and on market concentration? So in a study that I've been doing together with a few colleagues, Christian Peukert from HEC Lausanne, Michael Batikas from Rennes School of Business, and Tobias Kretschmer from University of Munich. In the study, we have been interested in exactly these questions concerning the GDPR. So the setup we are using is we are looking at third-party trackers used on websites. So this is an example of the New York Times homepage. If you go to the New York Times homepage and you watch this on the browser, then you actually do not only see content from the New York Times homepage itself, but the New York Times homepage will call lots of third-party trackers and other services that your browser will then seamlessly integrate into your browsing experience. And so the way this works is, this is another example from, if you go to TechCrunch, then if you look into the HTML code, then the web page itself would call these iframes or Google Analytics scripts, JavaScripts, and so on, would go through all these third-party domains, fetch content there, and then integrate this into your website. And so in the study, what we are interested in is to what extent these calls of third-party services by a website have changed before or after the GDPR. And so what we did in the study is we used a kind of unique data set tracking websites and technologies over time. It's about 100,000 websites that are kind of high ranking in Alexa ranking, so very popular websites. And so we use a archive, which is called HTTP archive, which is a bit similar to the Internet Archive, which some of you may have seen. So the HTTP archive basically goes to websites and stores them, and stores all the third-party requests that the website initiates, and does this on, I think, a bi-weekly basis. And so we have, over an extended period of time, 18 months, we basically can see whether websites have changed the way in which they are calling third-party web services by issuing HTTP requests. And we have information about what happened before the GDPR and after the GDPR in May 2018. So I don't want to go into the details of the study. I basically want to highlight two findings from the study. So first, we were interested in the territorial effect that GDPR has. So so if you look at the highlighted cell here in green, what you see is this is basically, we're looking at websites that are located in Europe and are typically accessed by European consumers. And so what you see here is, around on May 2018, the amount of third-party domain requests by websites decreases by about 7%. So what does this mean? This means that a website in the European Union, such as Le Monde, the French newspaper, would issue less third-party domain requests, less calls to web analytics, Facebook like buttons, and so on, around the introduction of the GDPR. And to some extent, this is in line with the GDPR because the GDPR is about data minimization. So you want to collect less data, or you want to make sure that companies collect less data. And so this is kind of a sign that to some extent, this seems to have had an effect. Now, what's interesting is that you see this effect not only for websites that are located in the EU and are targeted towards EU audience, you also see this in other cells. So you see this if the website is located outside the European Union, but still targeting EU's consumers. You also see this for websites that are located within the European Union, but where the audience is typically outside the European Union. But most interestingly, you also see a certain drop in cases where the website is located outside the European Union and the audience is also outside the European Union. So let's say, Los Angeles Times, which typically doesn't have a huge European Union readership. So it's primarily, a newspaper that's targeted towards, the LA community, or at least an American US community. Even for websites such as this one, on average aggregated, you see a certain drop in the number of third-party domain requests. So why is this interesting? This is interesting because this relates to a theoretical argument that the European Union has been successful in influencing global, privacy policy making, even beyond its own borders. And we think that this is one of the ways to give some empirical insights about that the strategy may have actually worked out. So that's the first thing to keep in mind, that GDPR may have had an impact outside the territorial scope of the European Union. The second one, which we focus on this study, is to think about changes in the competitive landscape. So websites such as the New York Times use third-party web technologies for analysis, tracking, and making sense of consumer browsing behavior. And so we look at in this study at which firms are operating and offering these web technology services, these third-party services, and we observe whether the market composition in this market is changing before and after the GDPR. And so what we see here is that basically market concentration is increasing after the introduction of the GDPR, and the way we're measuring this, we're looking at the Herfindahl-Hirschman index, and we see an increase. Now, what's interesting about this is that this market is really dominated by Google, and Google can actually increase its market share in this market, although the market, overall is shrinking. So, less websites after the GDPR has been introduced are using third-party web technology providers, but within this, shrinking market of web technology providers, Google actually wins market share in key areas of advertising and analytics. I don't want to go into details of this study, and of course it's more complicated. It has some caveats. There are issues with, causal identification and so on, but that's for another talk. And this is, this study is part of a, emerging literature that tries to use empirical methods in order to identify what the effects of the GDPR is on a dimension, on a multitude of dimensions. Now, what are our takeaways? At least from our perspective, what we see in the study is that, after the GDPR, there is reduced data collection. There are changes in the way how websites use web technology providers. not only within the territorial scope of the GDPR, but also outside the scope of the territorial scope of the GDPR. And there are changes in the competitive landscape. Now, this arguably, as I have indicated before, relates to a theoretical argument that Anu Bradford from Columbia and other scholars have put forward over the last years, that the European Union in various fields of trade policy has been very effectively using its regulatory power to export rules beyond the boundaries of the European Union. It also hints towards a trade-off between consumer protection and competition policy. So it could be that the GDPR was great for consumers because the data was better protected than before, but at the same time you also observe, not only in our studies but also in other studies, an increase in market concentration in some of these markets for web technologies, and you see that some of the winners in this game may be large tech companies, American tech companies such as Google. And so that's another dimension which I want to point out, that if you want to regulate in one dimension, such as data protection or consumer protection, you have to take into account that there may be indirect effects in other areas. So what are lessons for that we can draw from this experience for regulating AI? So I want to put forward 2 or 3 ideas of this. So first, it is really challenging to predict ex ante and evaluate ex post the success of regulatory strategies. So this idea about the GDPR helping Google increasing its market share, that's not something probably which the European Commission intended when it created the GDPR or proposed the GDPR, and it was pretty hard to figure out whether this would take place or not. And so I think as policymaking in that space advances, also the methods that we're using in order to evaluate and predict regulatory strategies here have to develop and have to get more advanced. So just an anecdote, in 1996, the European Union created a database directive, which was a copyright directive, whose goal it was to protect data as such by a sui generis right that's related to copyright. This was in stark contrast to the United States, which after the Feast Supreme Court decision held that data as such is not copyrightable. So, and the explicit goal of the database directive was to basically help the European database industry through a protection strategy. A few years later, the European Commission issued a first evaluation of the database directive by basically looking at the directory that existed at that time of all the databases that were created in North America and in West Europe. And then, this directory of databases showed that the database production in North America went up and in West Europe went down. Of course, this has tons of methodological problems, because who knows what goes into this directory, who defines what a database is. And I'm just showing this here because, of course, going forward, we need much more fine-grained methodologies to think about how to evaluate these regulatory interventions. Now, the second lesson is, I think it's very important to realize that regulating AI can have unintended consequences. So, the GDPR arguably led to, more concentration because the compliance costs are so high. Only large companies may be able to comply with the GDPR, and this basically drives, smaller competitors out of the market. And so with regulations such as the AI Act out there, one has to think about whether there are similar effects going to be, and whether that's from a policy perspective something which we want, or whether there are things which we may want to do about this. The second thing is that we should be aware of the fact that a regulation such as the AI Act may not only have an effect in Europe, but also beyond. And that may be a desirable thing, but this idea that you could restrict the territorial scope of these regulations to a particular territory, I think is not going to work. And so all this shows that there is a trade-off between AI regulations and other areas of regulating the economy, and we should be aware of these trade-offs. Because the extraterritorial application may lead to a global race to the top, where certain countries or regions, such as the States, European Union, perhaps also China at some point, are trying to set global standards that then apply to everyone or to nearly everyone who's involved there. Now, I want to close with a final thought on what is one reason behind this strategy of the European Union. And one of the reasons is arguably that the European Union has realized with the GDPR that if it plays the game nicely, it can actually become a global leader in privacy setting, in rulemaking. And so, most likely the European Union is also trying to replicate that experience in the space of AI. And I think this is an interesting strategy. I think what we miss from a scientific perspective are kind of good theoretical and methodological tools to evaluate whether regulating technology as a technology enabler actually works. So whether by regulating that technology, we actually help the industry to flourish and to develop. So I recently got a quote somewhere. I unfortunately don't know who said this, but I found it applies very nicely. So the United States invented Silicon Valley, and the European Union invented the GDPR. So there are questions about what does this mean for innovation in that space, and under what conditions should a government intervene in order to set the stage for a technology to develop? And I think we are basically just missing, good concepts and data to provide final answers to the questions. So with this, I would like to close. I would like to thank you for your attention, and I'm looking forward to any questions you may have.
Thank you, Stefan. My name is Elliot Ash. I am one of Stefan's colleagues at the Center for Law and Economics. I'm the assistant professor of law, economics, and data science. I would like to second Stefan's welcome on behalf of ATH Zurich Center for Law and Economics to everyone in today's conference. We have just 4 minutes for questions, and I have a couple that I collected from the chat, which I will just say for Stefan in order, and you can answer them together or separately. The first was, are there different rules for commercial products using AI versus non-commercial products, for example, by academics or free and open source AI systems by coding collectives? And second, how are EU policymakers addressing the issue that technology moves faster than regulators? How do we regulate not only the known AI risks, but also assess future threats?
Perhaps I can start with the second question. These are both excellent questions when it comes to how to adapt to a fastly moving regulatory space. I think the strategy is to say, let's basically create a regulatory environment that's very abstract. So we're only going to talk about AI in general. It encompasses a lot of stuff. And then we're going to create categories like low risk, medium risk, high risk, and everything else we basically leave up to the regulators, in the future, who are then supposed to fill this in and then say, all right, that technology is a problem, that technology is not a problem. And I think to some extent that's a wise strategy. And to some extent, in the space of the GDPR, this was a bit similar. This was about, this processing of data, and it's very, very abstract. But it also shows that, sometimes this strategy comes to a limit. So if you think about, this entire discussion in the European Union about, how to regulate cookies, are they allowed, pop-up, not pop-up, e-privacy directive, e-privacy regulation, database, GDPR, and so on. So sometimes if the regulator then, for whatever reason, wants to be very specific, then things take sometimes a lot of time. And so I think this is just a general trade-off that policy making in that space has to deal with. Sometimes you can stay very abstract and create general rules, and they will uphold for a time. And sometimes you have to be specific, and then sometimes you're just too late. And if you think about antitrust in that space, it's exactly the same problem. So I think there's no easy solution to this, but I'm not aware that any country has found an easy solution to that kind of problem. On the first one, are there different rules on commercial versus non-commercial actors? So from my understanding, the only difference is, I mean, it may indirectly have an impact because there is a risk categorization between low risk, medium risk, and high risk technologies, and so it could be that some of the non-commercial actors are more operating in the low risk environment, but there is no kind of formal distinction between this. And to some extent, if you say we are really focusing on the risk, so we are looking at the outcome, then you could say it doesn't matter whether the actor that's creating the risk is a commercial or non-commercial.
Great, thank you, Stefan. So this will conclude the Q&A, and we can now move to the next panel.